Good afternoon, everyone, and welcome to the Crips AI and Data Show. My name is Matthew Holman. I'm a partner here at Crips. And today we are bringing you the latest installment of the AI and Data Show. We'll be covering all kinds of fascinating topics. In the room, we will have Tim Payne KC, one of the leading barristers in data protection. He'll be taking us through his thoughts on the Uber fine, all things international data transfers, and the complexity around transfer risk assessments. We'll also do a bit of an update on things that have happened. But before we do all of that, it's time for See It, Say It, SAR It. Now, for those of you who can't remember, I think it was probably about May time that the band Oasis reformed. I'm a massive Oasis fan. And like many thousands, hundreds of thousands of people, I went onto the Oasis website and tried to subscribe to get some tickets. Here is a screenshot of me on the website. You see my email address there. I'm trying to get into the pre-sale ballot, and I think if we zoom in on that, you'll see in a second there it is that the red box is shown in red because I'm trying to navigate past the consent to marketing communication without giving my consent, and I can't do that. The red box isn't letting me progress without giving my consent, which is a bit annoying. Ultimately, I do give my consent because I want to get tickets. I consent to Oasis sending me marketing communications by SMS, even if my number is on a do not call registry. There's only one option here. The option is to tick the box, which I eventually do because I want to get through to the ballot and get some tickets. I do tick the box, I do go into the ballot, and I don't get tickets, which is very frustrating, but c'est la vie. We then presented this to all of you on the AI and Data Show 2 sessions ago, and I put it to all of you that this was not compliant with the ICO's Direct Marketing Code of Practice, and it wasn't compliant with the PEC regulations. Many of you agreed, and we put a survey out there saying, should we ask the Oasis production team, I presume they weren't asking Liam and Noel directly, what the compliant, why they weren't as compliant as they should be, and whether we should report them to the ICO. All of you said that we should. So this is me emailing the Oasis team, and I said, hello, my name is Matthew Holman, and I'd like to complain about your compliance with data protection laws. At the Oasis pre-sale ballot, I had no choice but to consent to marketing. This doesn't comply with data protection laws. Please, can you explain why you failed to comply with those laws? Oh, what a snidey question to ask there on my part. To be fair, Oasis's production team came straight back. This is what they said. Dear Matthew, thank you for taking the time to email us. The fan ballot is only open to Oasis fans registered on the Oasis fan list, which is now managed by the OpenStage Artist platform. As the ballot is only open to registered fans, a link has been provided for any fans to register. The Oasis/OpenStage privacy notice relates to registered fans, and as such, the fan data is collected only for Oasis communications and marketing purposes. And then it says at the bottom in highlight, we apologise if the original wording was not clear for you and confirm that we have now changed this and would like to thank you for pointing it out. I'm not sure they're really thanking me, but let's have a look, because I'm not actually sure they answered my question at all. So here I am responding saying, dear name, thank you for your email. I'm not really sure the response you've offered answers the question posed. I'm not overly concerned about the Oasis fan list, and I don't require you to delete my data. Here's a screenshot of me registering, and fast forwarding to the end of that section, I ask, why weren't there 2 boxes, one saying I consent and the other saying I don't consent, or something like that? Do you think I got an equally courteous response? Well, let's find out. Here's a response. It opens with Matthew, not dear Matthew. And then the best sentence of all, many lawyers have been through this. Any email that opens with the sentiment that many lawyers have been through this, I feel, is destined to be picked apart. They say, in summary, number 1, the ballot was a private ballot designed only for members of the Oasis Club, which is in inverted commas. I'm not entirely sure who they're quoting. As a private ballot, the consent options you mentioned are not required. Number 2, so you joined the Oasis Club in order to enter the ballot, and then in underline and highlights, a rule of being in the club is that you consent. Now, I should add that the highlights and underline is mine. We'll come back to that. Number 3, some of the promotional wording did not initially make this clear, but as soon as we spotted it, we fixed the problem. And number 4, although we didn't legally have to, we included the consent box to try and make things as clear to the fans as possible what was going on. A sentence that doesn't really make very much sense. And then it ends with this sentiment. We really are trying to do the right things for both fans and artists. I wonder if the approach to dynamic pricing could be measured against the same test, but we'll possibly put that controversial issue into a pub discussion at another time. Because I want to show you what I think about these 2 highlighted sections. A rule of being in a club is that you consent. Well, another way of reading that sentence is you have no choice about marketing. If you are in the club, you have to consent. And another way of reading the other highlighted sentence, the one that says we included the consent box to try and make things clear, is we showed you a consent box that was meaningless. You didn't have a choice at all. Now, all of this is clearly very not compliant with PECA. If you're not sure about what I mean, then please do have a look at the ICO's Direct Marketing Code of Practice, which makes it very clear that in order to send direct electronic marketing, you have to have the consent of the individual and or possibly rely on the soft opt-in. Neither of those are occurring here. So, in response to the request from the SAR, from the last webinar, this was reported to the ICO, who've responded and said they're going to look into it. Now, I, like many of you, am a very busy professional, so I almost kind of forgot about this and moved on, especially as we did this back in September, until last Friday just gone, when this email landed in my inbox as if to remind me that I was being marketed to without consent. The beloved Gallagher brothers sent me this, and if we blow up the wording, it says, "Welcome to the Oasis mailing list. You are receiving this email because you entered the ballot and opted in to receive marketing." I didn't opt in to receive marketing, but I'm still getting the request. So naturally, I forwarded all of this to the ICO. If you want to see what they have to say about it, tune into the next show. Let's come back into the room. But I feel like it's worth reminding you all that See It, Say It, SAR It is a bit of light-hearted and entertaining way of looking at the world of compliance, because ultimately we can all learn a lot from how not to do things. If you see something in your daily life that doesn't look right and it relates to data protection, then don't send it to the British Transport Police. Instead, send it to us at Crips. We have an email address set up for this. It's called seeitsayitsar@crips.co.uk. Whatever you find, we'll get a team of people looking into it. And if we think there's some merit in it, we'll get in touch with the company and see if they can explain why they aren't quite compliant with the law. Now, this is the moment in the show where we do a bit of an update on the news, things that have happened in the last 4 weeks in the world of data protection and AI. And we're going to start with the EDPB's guidance on on cookies. So I don't know if you missed it, but some of you may have. On the 7th of October, the EDPB published updated guidance on the e-privacy directive, Article 5.3. Sorry, my clicker isn't working, so I'm not sure you'll be able to see the tabs as they pop up on the screen. Basically, Article 5.3 is the part of the e-privacy directive that talks about having to set cookies, you need to have consent. That is transposed into UK law through the PEC regulations and Article, there it's on your screen now, Article 6, I believe. What's interesting is that this updated guidance, which is technical guidance, speaks very potently to some of the ad tech issues that have spilled over from the cookie deprecation topic that has been bubbling around for a couple of years. As many of you know, Google decided to deprecate third-party cookies. That then resulted in a promulgation of many different types of solution to deal with tracking online behavioral advertising. I suppose the most obvious ones, or the best known, being Google Consent Mode and Google Advanced Consent Mode, but there are plenty of others besides. We haven't had for a long time guidance on how the cookie laws are interpreted with that kind of tracking, but now we do. It's draft guidance, and it's very, very interesting because it suggests that some of those solutions, particularly Google Advanced Consent Mode, do require consent. I'd encourage any of you working in this field or that deal with this stuff on a regular basis to have a look at that if you can. particularly the 6 interesting use cases at the end of the guidance, one of which clearly says that using an IP address for identification purposes will result in processing of personal data, or is likely to, and that is essentially a bullseye for Google Advanced Consent Mode. On the 7th of October, the EDPB published its eagerly awaited opinion on the relationship and identification duties and relationship management duties between controllers, processors, and sub-processors, a topic that is dear to all of our hearts and the kind of thing that we all spend a lot of our working lives dealing with. Some of what they say in that opinion is actually just a repeat of things you've read before. So expect lots of content around the need for you to be up to speed on everything that's going on, the need for you to have transparency over the full depth and breadth of your supplier networks. But there are some things that are new, and there's one sentence in particular that's been doing the rounds in the world of data privacy, and I'll read it to you now in case you've missed it. It's this sentence. The EDPB concludes in this opinion that controllers, which is pretty much most of us on this webinar, should have the information, have all the necessary information on the identity of all processors, sub-processors, etc., i.e. name, address, and contact information. And that information should be readily available at all times so that they can best fulfill their obligations under Article 28 of the GDPR, regardless of the risk associated with the processing activity. The reason I flagged that up is because it, in many respects, does not reflect reality at all. Most organizations will have some of this information for high-risk processes, but they won't have a lot for low risk. What the EDPB is clearly saying is you should have this regardless of the risk involved. That probably adds quite a significant burden to many of us working in this sector. You should, if you're advising on processor and sub-processor relationships, think about adding some of this stuff to your procurement processes to make sure you get this information up front, possibly even adding it in as some kind of contractual requirement to supply it. The next thing I'm going to mention to you on the news update is the 9th of October EDPB new guidance, which is currently out for consultation. EDPB has been publishing a lot of stuff in October. This is on legitimate interests. At the risk of offending lots of people, I think it's probably the most interesting of the three. Sorry to the EDPB drafts people if you're watching. It's very relevant to all of our working lives. If you spend a lot of your time, as many of us do, advising on what is a legitimate interest, when can it be applied, how can it be disapplied, when is the balancing test met or not met, then this is something you really need to print off and read. It's only about 20 odd pages long. And it tackles one very interesting issue, which is whether or not a commercial interest always passes the first limb of the test. This in itself is a follow-on from the Dutch Supervisory Authority's fine to the Royal Dutch Tennis Association. That was a fine of, I think, €500,000, something in that region, for an organisation that decided, without really analysing why, that its own commercial interests was a de facto legitimate interest. The guidance, give you a spoiler alert here, concludes by saying that a commercial interest will probably be legitimate, but the organisation should not always assume that it is. In many respects, it's a narrowing of the use of legitimate interest by the EDPB and European counterparts at a time when the UK is actually looking to expand its own interpretation of legitimate interest. Maybe we'll pick that up on a different webinar. What else has happened? Well, the House of Lords European Affairs Committee published a letter on UK adequacy. So anyone who's watching all things international data transfers will know that UK adequacy decision is up for renewal in June. The one, it's a very long letter to the Secretary of State. I'm not going to read it all out to you, but basically they conclude with an overwhelming decision that adequacy is beneficial to the United Kingdom and must be maintained pretty much at all costs. Here is one sentence that I thought I'd read to you because it's relevant to the second part of our show with Tim. They say in the letter, almost all of the witnesses to the European Affairs Committee assessed as less than satisfactory the alternative mechanisms that may be used for international data transfers if no adequacy status is in place. Alternative mechanisms were seen as more complex, more burdensome, more costly, and more limited in scope. The overall feeling in the letter is one of, I think, optimism. I think there's a general feel that adequacy should be renewed, but the challenges from regulatory oversight and the challenges from a potentially divergent data protection regime are all noted. Watch this space. We'll bring you more updates on adequacy as it rolls by. But that brings us to the most important piece of news. If you've missed this in the month of October, then you really need to write it down. The government has published a brand new data protection bill. It is the Data Use and Access Bill. In many respects, it is the successor to the Data Protection and Digital Information Bill published by the previous government, although there are some differences. It's a very important development. It's such an important development that we will pretty much dedicate most of the next show in December to digesting that for you. So if you want to learn more about the coming changes in data protection law, tune in then. Let's come back into the room. That is almost the end of the news. There was so much to update you on the news that I didn't want to overload it because there was a lot of things that have happened. So I haven't really said anything about the fact that Norway has increased the age of 15 to the age of 15. Anyone who wants a social media account, that's a fascinating area of development all on its own. Haven't talked about the US election at all, and the fact that there is a increasing clamour for a federal AI law. On the 23rd of October, the pro-AI regulation lobby issued a very strongly worded call to arms from both parties to produce something to protect citizens, and both parties seem to be paying lip service to it at the minute, although that changes on an almost daily basis. Some dates for your diary. If you haven't already spotted these, then they're really important and definitely worth flagging. The ICO is holding a 1-hour webinar from 1 till 2 on the 12th of November on AI and data protection regulation. Cribs will be there on account of our work with the ICO's Gen AI consultation, but I believe it's free to all. Please do come along and sign up for that if you can. It will give us an interesting insight into what the ICO is thinking about Gen AI regulation. And lastly, it's the IAPP Europe Congress on the 20th to the 21st of November. So some important dates for your diary, that Congress taking place in Brussels. A whistle-stop tour of all the things that are going on. We bring it to you like that because if pretty much everyone in this industry knows that the world moves incredibly quickly, and I want to do the best at bringing you all the things that were important. There are a lot more other things that we could have brought, but I wanted to make sure we had enough time to speak to our learned guest. Tim Pitt-Payne is here in the studio with me. Tim is a barrister at 11 KBW and is widely recognised as one of the leading barristers in the world of data protection law. Tim, welcome to the studio.
Thank you very much. Very good to be with you.
It is obligatory that anyone who comes on the AI data show, however preeminent and important they are, must be asked some embarrassing icebreaker questions.
Better say yes then, haven't I?
In the next 60 seconds, I'm going to ask you a bunch of questions that you have to answer with just one word. Are you ready?
I'm ready.
My favourite food to eat is?
Pasta.
My desert island disc would be?
Barks Matthew Passion.
Oh, good choice. One of the best things about being a barrister is?
Colleagues.
Not arguing. My favourite kind of holiday involves?
Walking.
My favourite part of London is?
Bloomsbury.
Bloomsbury, good choice. If I could go back in time to any period of history, I would go back to?
The Ice Age.
The Ice Age. My least favourite domestic chore is?
Bed making.
I drive a?
Skoda.
Very reliable. If I wasn't a barrister, I would be a?
Journalist.
The first thing I would do on a Friday after work is?
Wine.
Wine. And the one item I couldn't live without is?
Got to be my phone.
Phone. Such a child of the 2020s. Well, I agree with almost all of those. And well done. You've absolutely passed the test. Please start by telling us a little bit about how you came to be a barrister.
Okay, so I was quite an argumentative child. Didn't do much sport, debating, stuff like that. I loved. I used to watch that lunchtime courtroom drama, Crown Court. I don't know if you remember that one. Got me into the idea that this just might be a line of work that I would enjoy. And when I did my university law degree, I was surprised that I also found I actually enjoyed the law as a discipline. And I spent a couple of years as an academic lawyer, but I really always intended to go into practice. So I landed at 11 KBW in the early 1990s, and I've been there ever since.
No looking back?
No looking back, absolutely.
And now you're one of the leading data protection cases in the country. It feels like this would be an appropriate time for us to start our discussion about all things international data transfers and the international complexity that comes with AI and data privacy. I should say that we are live for chat, so if you have any questions for Tim, please do fire them into the chat section of the Zoom box, or if you're on LinkedIn, use the chat mechanism that's there. We'll take your questions as many questions as we can fit into the time that we have. However, there is one case that you must all know about. I've mentioned it a few times on the webinar already, and we're going to do a quick digest of it for you now. It's the most important case in international data transfers, the Uber fine. So Uber was investigated initially by CNIL on account of complaints by French taxi drivers who were providing services for Uber in France. That was then escalated to the Dutch Data Protection Authority because Uber's headquarters are in the Netherlands. The Dutch DPA found that Uber collected personal data and special category personal data of drivers and transferred it to the US. That data included account details, taxi licenses, location data, photos, payment details, identity documents, and in some cases, criminal and medical data of drivers. So really the whole shooting match of sensitive stuff. One of the things that came out of the investigation was that Uber had stopped using standard contractual clauses in 2021. Now we don't quite know why that had happened, and we'll talk about that more about that in a moment. For 2 years, from 2021 to the point the investigation ended, there was no appropriate transfer mechanism in place, and so the investigation concluded that Uber had been in breach for that 2-year period. At the end of that period, Uber then relied on the data protection framework. Now, we're not going to talk too much about the data protection framework today. Safe to say that it's the successor to Privacy Shield. For its naughtiness, Uber was fined the very eyebrow-raising sum of €290 million. Uber has confirmed that it intends to appeal, and it's actually the third fine that Uber has received from the Dutch DPA in that period, the others being a €600,000 fine in 2018 for not reporting a breach in 72 hours. Hashtag to all DPOs and advisors, if ever you've been asked, will we get in trouble for not reporting on time, I'd put that case in your back pocket. And also a fine of €10 million in 2023 for not fully disclosing retention periods to the ICO. Naturally, we want to hear what Uber have to say about this. Their spokesperson said, "This is a flawed decision and an extraordinary fine, which are completely unjustified. Uber's cross-border data transfer was compliant with the GDPR during a 3-year period of immense uncertainty between the EU and the US." And the Tech Industry Association CCIA head of policy, Alexandra Rohr, said, "The decision ignores reality. The busiest internet route in the world could not simply be put on hold for 3 years while governments worked out a new legal framework for these data flows." Now, there are a number of unknowns with this, and the first big unknown is why on earth Uber stopped using the SCCs at the end of 2021. Is it because they found complying with the EDPB's guidance on supplementary measures hard? We just don't know at this point in time. We also don't know how many data subjects have been affected. It could be the indication from the hearing is that it's probably less than 1,000, but we don't actually know the total number. That could have been relevant, possibly. We also don't know whether any of those data subjects were actually exposed to and the subject of investigation by US authorities. So did they suffer actual harm, or is this just a hypothetical issue? Finally, we don't know on what grounds Google is appealing. We haven't seen any detail there. So there is still a lot up for grabs with this decision, but it is the most important decision right now in the world of international data transfers. Let's come back into the room and we'll talk to Tim about it. Tim, do you think that this is this fine is something which UK businesses should pay attention to, or should we dismiss it as just a wacky and disproportionate European judgment?
I think it would be a very bad idea to dismiss it, even for those businesses that don't have an EU presence and are not directly subject to EU regulators. I think historically we haven't seen a lot of enforcement action in this country from the ICO in relation to international transfers. This is the sort of decision that has the potential to shift that in terms of putting those issues about international transfers, putting them further up the regulatory agenda, but also putting them further up the agenda for individuals and also for NGOs, for privacy activists. I think it's quite interesting at the moment, for instance, to see that the Good Law Project is focusing more of its attention on data issues, data protection issues. This is just exactly the sort of thing that is going to encourage NGOs to focus on issues around international transfers. So I would say, for heaven's sake, don't just treat this as something that you can ignore.
I would agree entirely. Were you surprised by the amount of the fine?
I would say I was astonished by the amount of the fine. I mean,
you were as well.
From the face of it, it does seem an extraordinary fine, and we haven't seen fines at that level in the UK for anything in terms of fines that have actually gone through and been imposed. I mean, you can say, okay, on the one hand, it's a high-profile business. It's had a couple of previous EU fines. The period of the alleged breach was quite long. Some of the data was very sensitive, as you were saying earlier on, e.g. location, health, criminal records. And certainly the regulatory story seems to be this wasn't a case where there was an attempt at compliance which was inadequate or insufficient. The regulatory story seems to be this was a situation where there just wasn't compliance. There was no transfer mechanism was put in place during quite a significant period.
What would be your one takeaway for UK and EU businesses that are transferring personal data without a compliant Article 44 mechanism?
Well, I suppose if we go back to the one-word answers that you were having from me earlier on, I think the one-word answer would be don't. If you think that you're in that situation, seek legal advice. I think the takeaway has to be don't assume that this is a purely technical breach and that nobody will ever bother about it. And remember that the Uber fine, that followed a number of complaints by individuals, by individual drivers. And that ended up with CNIL, the French regulator, and then with the Dutch regulator as the lead authority. But I think the other thing I would say is, well, don't despair, because I think the ICO's attitude historically to international transfers, and I think one sees that in a lot of their guidance, the ICO attitude has very much been not trying to be a showstopper, but saying, look, international transfers, you need to go about them in the right way. So it's much more a kind of proceed with caution approach than a we want to shut down your business approach. So don't despair, don't panic, but don't ignore, I would say.
One thing we haven't done so far, and I imagine there are a fair few of you watching thinking this already, and by the way, I should remind you that the chat is open. All the questions you've got for Tim and more, please do put them in, and we'll get to them as soon as we can. We haven't talked about standard contractual clauses. One thing that we must all be thinking is, well, hang on a second, Uber. You protested there was no other way. You suggest there was this significant period of political uncertainty between the US and the EU, but there was another way. The GDPR Chapter 5 makes it pretty clear what that way is. Article 46 talks about the use of, amongst other things, standard contractual clauses. Those standard contractual clauses were in themselves subject to a challenge in Schrems. Do you think the SCC, standard contractual clauses regime, is likely to be challenged again in the near future?
I think there's a high chance of further challenges. As you say, there was a challenge in Schrems 2. It didn't wholly succeed. They weren't struck down, but there was the emphasis from the judgment about the need for a proper risk assessment as to whether SCCs did deliver adequate protection in the particular circumstances of the case. So you've got activist-driven litigation with some track record of success. A lot of that litigation was driven by concerns about the vulnerability of user data, particularly in the US. I don't see those underlying concerns as being likely to go away. If anything, I think we can anticipate, perhaps depending on the outcome of the US presidential election, that there may be increasing levels of concern from European actors, particularly NGOs, as to, is the US a data which fully respects the rule of law, which fully respects human rights to European standards? Is it a data which, is it a destination which European citizens can expect to trust with their personal data? And I think all of those things would feed into an increased risk of future challenges.
But in many respects, what you're articulating there is simply what the CGU articulated in the Schrems judgment.
Exactly, and those concerns haven't gone away.
Which I suppose leads quite neatly to transfer risk assessments, because many of us on the call spend our lives now writing transfer risk assessments. Indeed, there are whole divisions of legal teams given over to the task. Any of you watching, by the way, who've only recently come to the world of data protection and AI and think that transfer risk assessments have been around forever, they definitely haven't. They really only came to life post-Schrems 2. I suppose they existed theoretically before then, but it wasn't until the EDPB published its supplementary guidance on interpreting Schrems 2 that transfer risk assessments fully came to life. Since then, many of us have spent a lot of time trying to write down what is quite a complicated and, dare I say, political assessment of data protection governance in foreign jurisdictions. In practice, how are most organisations approaching TRAs in your view?
Well, a question, Matthew, that I asked you earlier on was whether anybody was using ChatGPT to write their transfer risk assessments. I haven't seen that so far. I have to say, I'm sure as a lawyer, and particularly as a barrister, I see a skewed sample of clients. I think I probably see a mix of the most compliant and conscientious who want a second opinion as to whether they're getting it right, and the least compliant who are now in a panic because they realise that their past may be about to catch up with them. But I think across the whole spectrum, people find TRAs particularly difficult, and I think the difficult thing is the almost political assessment that you have to make about standards of protection in the destination country, both standards of legal enforcement, is it going to be easy to enforce data subject rights there, and also generalised respect for human rights and the general state of the legal system, the legal culture. Those are really difficult assessments to make. I mean, it would make our life so much easier, for example, if there was some authoritative UK government assessment which said, here are the high-risk jurisdictions, here are the low-risk jurisdictions, here are the ones that are in between, and here are the things that you need to look out for. But of course, the politics of producing an assessment like that would be very fraught indeed. So people are having to try and do it for themselves. And I think that's hard for everybody.
Let's go to Q&A. One of the questions that we'll start with was actually crosses over with the question we were going to pose. It's about the potential for a two-tier regime between the EU and the US, particularly regarding AI. Because for those of you who aren't aware, in June, Meta said that it was going to pause the rollout of some of its AI development in the EU, and the reason it was going to do that was the alleged uncertainty around regulatory regimes in the EU, particularly regarding AI and data protection. Do you think there's a risk of a two-tier AI ecosystem occurring on account of AI and data protection laws?
Well, there seems to be some evidence of a potential risk. It was a very interesting open letter from various tech companies signed by a number of people, including Mark Zuckerberg, in late September. And it was essentially saying that there were two areas where Europe was at risk of missing out. One was the open AI systems, and the other was the multimodal systems that are now being developed, which try and apply AI across the whole range of text, image, video, etc. And the concern that seems to be driving this on the surface from the tech companies, including Meta, is not a concern so much about the EU's AI Act. It's more a concern about the way that the data protection framework is operating, the concern of European regulators, e.g. the Irish regulator in relation to Meta, the Italian regulator last year in relation to ChatGPT, concern about the use of user data to train large language models, to train the AI systems.
Yeah.
And that seems to be the pinch point where some of the US tech companies are saying we're really concerned about EU regulation.
Thank you for all of the great questions that are firing into the Q&A. We will do our best to get to all of them. Here's an interesting one and a slightly technical one. If the Uber US entity, so the entity that was importer, was really a joint controller with the Dutch entity, so joint controller with the exporter, would it be directly subject to the GDPR and therefore no transfer mechanism necessary?
That, I think, is a very interesting question. I mean, the ICO has taken the view that if it's a transfer from the controller in the UK to the controller's overseas establishment, then that's not, strictly speaking, a transfer. It's not a relevant transfer. It needs to be from entity A to entity B. I think the case where you've got joint controllers like that is an interesting edge case. No indication so far that that might be something that Uber is trying to run. But, I mean, we don't know what their line of argument is going to be. Where you're looking down the barrel of a fine like that, you're going to run every single argument you possibly can. Absolutely, yeah.
Another question, which we get all the time, is can you vary SCCs if the provisions are too onerous?
You have to be really careful about that. So basically, the point about SCCs is that they are there to provide a baseline minimum level of protection for the data subject. So if you're going to vary them, if you vary them in a way that doesn't have an impact on the data subject or that makes the data subject's position better, then that's going to be okay. But if you vary them in a way that worsens the position of the data subject, then that is likely to invalidate the standard contractual clause, i.e. you will not be able to rely on it as a transfer mechanism. So you need to be really careful about varying.
Another question is, have you seen any organisations transfer impact assessment cover together all transfers to the US and or all transfers to China? Would this tick the box for compliance?
I haven't seen that. I don't know. Is that something that you've seen, Matthew?
It's a good question. I actually have seen an example of an organisation try to draft a transfer risk assessment where they said, this is our assessment of all transfers to pick a country, and the country in question was China. And it was done predominantly for ease of governance rather than any other reason. I think they had lots of flows in and out of China, and they thought, well, we could write 20 TRAs. They will say 90% the same thing. Or we could write one TRA and just say all of these data flows are analysed like this. So that was the logic for doing it.
Yes, I mean, I don't think you need... It's a difficult one. You don't necessarily need 20 separate documents. You know, one doesn't want to be too mechanistic about that. But I would be really hesitant about trying to do a one-size-fits-all where you said, well, look, all of this is a TRA that is intended to cover any data transfer that we might do to China over the next, say, 3 years or 5 years, because then you don't have the flexibility to deal with different circumstances, changing circumstances. You know, how are you going to deal with different types of data, different use cases, different categories of recipient? Even in China, you know, you're going to have different categories of recipient there.
I think also the difficulty with that idea, the idea that you do one for all, is that the EDPB guidance is actually quite prescriptive on some of the things you require. You rightly mentioned data flows, types of data, regular updates and things like that. And it almost misunderstands the nature of a TRA, which is far more about looking at what risk does this data transfer create when it's moved out of a deemed safe environment into a deemed unsafe environment, as opposed to talk about the politics in this country, which is, I suppose, a little bit how you get to the logic of, well, we don't want to do that 20 times, but that actually isn't quite what it's about. One more question, and then we're going to move on. But thank you for all of the questions. Please do keep putting them in. We'll come back to you after the show to those of you who've asked others. One we've had a couple of times is what's the normal position regarding indemnities for importers? Someone else asking the same question. How should one deal with indemnities between importers and exporters and SCCs?
Yes, I mean, as far as indemnities are concerned, so there's a kind of default position in the SCCs themselves, which is essentially that if you've got harm to which the importer and the exporter both contribute, the data subject should be allowed to sue either of them and should be allowed to sue either of them for the whole extent of that harm. Then, as between importer and exporter, if one of them gets sued, effectively the other one can seek a contribution based on the extent of the respective contributions to harm. Now, I don't see in principle any reason why importer and exporter shouldn't vary the liability position as between themselves. So have indemnities as between themselves that vary the default SCC position, so long as that doesn't prejudice the data subject. The important thing is the data subject should be able to sue whichever is their preferred target. They should be able to pick their preferred target, joint and several liability, and then indemnities shouldn't affect the position of the data subject.
Agreed. Tim, that was insightful. It was interesting, and I think it thoroughly covered the topic. Thank you very much for giving up your lunch hour to come in and hang out with us.
You're very welcome. Thank you.
It is that time of the show where we are very close to ending, and we always like to bring you as many updates in the world of AI and data as we possibly can. So I'd like to welcome back into the studio our AILs who are going to do three great things with me. Welcome Amy and James, who are both in the Crips team here. And as part of all the research that we do, which is like a daily thing, there's so much research that goes on here. Every now and then we come across some really fascinating use cases for AI, and we thought that it'd be great fun to share some of those with you. So, Amy, I'll go to you first. What have you seen AI doing in the last 4 or 5 weeks?
Yeah, so I found out that researchers at the University of Sydney have uncovered more than 160,000 new viruses in a single study.
Wow.
And this is the most amount of viruses uncovered in a single study in the history of research, which obviously was helped by AI. And I think it shows that going forward, who knows where it could take us. It might help with pandemic management, vaccine development, or even creating new ways to uncover more viruses in the future.
Fascinating. James, how about you? What have you seen AI do?
So I found that Anthropic, which is one of OpenAI's main competitors, has recently taught its model Claude to use computers in a more human-like way. So they are teaching it how to open a search engine and type into that search engine to get a result. So one of the examples I read was they was planning an outing for a group of friends, and they put in where it was going, the best place to go, and then sent out diary invites for that particular event.
Wow.
And kind of linking in with that, Google have updated the Maps application to have some of Gemini's features.
Right.
And they're aiming for users to be able to type in something like things to do in London this evening, and it would tell you what's on in London and how to get there. And it would tailor those to make them season specific. So obviously it's fireworks night soon.
Indeed.
And so it could be a fireworks show, whereas your results from last month would be quite different because there wouldn't be something specified to that season.
Interesting. So we have AI finding 160,000 new viruses, more than ever before in any other study. We have Anthropic with what sounds like a virtual assistant, and we have Google taking Google Maps and lacing in Gemini to do AI smart searching. Tim, let's come back to you, because it is finishing tradition to ask our guest which of the various new AI use cases most appeals to you. Which of those do you think is the best?
They all sound very interesting, but I'm going to go with the 160,000 viruses in the Australian study. Not just because it's Australia and I really like Australia, but because that does sound hugely exciting in terms. I mean, people talk a lot about use cases for medical research, and that does sound like a really, really exciting development.
Well, congratulations to Amy on winning this particular AI Three Greatest Things. It's not really a competition, but somehow I've made it one. That is the end of the show. It's 1:15. Thank you to everyone who joined in. We will be back on the 2nd of December at 12:30 when I will be digesting the Data Use and Access Bill for you. I should also mention that we are going to do an event called Cathedrals and Cocktails here at the London office on Wednesday, the 4th of December, 5 p.m. to 6:30. So if you were on the show today, we'll send you an invite to that. I should add that we aren't drinking cocktails in a cathedral. We'll just be drinking cocktails near a cathedral, a celebration of all things AI and data show at the end of the year. That's on the 4th of December. So that leaves me to thank Tim Payne-Casey and to thank our AI elves. And hopefully we'll see you in a month's time on the next episode of the AI and Data Show. Thanks very much, everybody.